Today's topic is communication with experts. Judex non calculat is a famous saying loosely translated in the judge does not calculate. It originates from the Roman legal concept that obvious calculation errors in a court decision are not harmful to the decision itself and can be corrected at any time. I personally often see jurists using this phrase for excusing their inability in math. Lawyers know, or at least should know, the law, but they may need a helping hand understanding technical aspects and difficult calculations. This helping hand for lawyers, such as counsels, arbitrators, judges, whoever it is, may be an expert. Today, we want to dive into the question of how to effectively communicate with an expert. We may also address the question, what is a good counsel-expert relationship, or what should be communicated between an expert and a counsel, and at what point in time. We are honored to have Campbell Jackson with us today to provide us some answers to these and probably even more questions. Campbell is an Australian living in the UK, and Campbell introduced himself to us prior to this event with the following words: I'm dealing with other people's problems. He is doing that as a partner at EY in London and as a chartered accountant and forensic specialist. Campbell regularly provides expert evidence and testimony across multiple jurisdictions, courts, and tribunals. He has over 25 years of professional service experience across multiple industries, including banking and finance, insurance, energy and resources, consumer products, and manufacturing. Campbell, I may hand over the virtual mic to you, and we are keen to hear from your expert's perspective how lawyers can communicate effectively with you.
Well, thank you very much, and it's a great privilege to be with you all today. I think, thank you for the warm welcome and the background. I think some context, though, for the audience. I'm not a lawyer, but I work with lawyers every day, and I try to make the complex more simpler, and that often culminates in evidence in courts and tribunals around the world. Today, I wanted to impart some practical experience and hopefully just make some key call-outs that can empower you in your work and to give you a perspective as to what it's like as an expert and what good looks like when engaging with counsel, and to give a realistic snapshot of what can really make a difference, right through to hopefully some practical tips and advice, take it or leave it, but certainly what I've experienced over my journey working with counsel and testifying at the end of the day. I do have a number of slides that I want to work through, but to manage expectations, I'm not going to cover everything on the slides. It's really just a reference point and for some takeaway material after this session. And I would be more than happy to take questions as we move through or explore issues further that are of interest to the group to make sure that you get the most out of the session. So the starting point for me on effective communication and the role and the interplay of the expert is really don't leave the communication to chance, and make sure you know how your expert is going to be positioned, how you are going to use them through the journey of a case or a matter, but most importantly, how those communications can surface right at the end when they're in the witness box or in front of a tribunal being challenged, to ensure that those communications are appropriate, robust and sound, to ensure that the expert can be relied upon at the end of the day and there is smooth passage to the facts. The key message number one for me today with communications with experts is recognition that the expert's paramount duty is always to the court and to the tribunal, and not as an advocate, and must maintain their independence and objectivity in all communications, in all opinions, written and verbal, and really maintain that standard. And as a testifying expert, that is the only principle that I'll operate under, and it is front and centre, and I'm mindful of it with every interaction and every communication that I have, to ensure that that paramount duty is always met without fear or favour, independence, objectivity, for the benefit of the court or the tribunal. If I pivot to communication with experts at a practical level, I see a lot in the work that I do, the concept of hired guns or opinions for sale, or a big name, a big brand, a big CV. But all too often I see that get unpacked when ineffective communication enters, or where the lines are crossed between what the expert should be doing, how they should be communicating, to how they do communicate, to the standard that's actually required. And I think going beyond the brand and the individual to go underneath into the detail about who that expert is, what they're like, what the team is, etc., will only assist in answering that first question of beginning with the end in mind to ensure that you've got the right expert. If I go directly to early communication in phases of actually selecting an expert, finding an expert, and going through, the selection criteria of who you're going to use and why, I think there's a number of key points that go to the very heart of effective communication to ensure that you do get the right person with the right skills. First and foremost, obviously, they've got to have the appropriate qualifications and the appropriate experience to be able to meet and opine on the matters that are in front of them. And the analogy that I use there in the context of effective communication is, do they actually know and can they communicate who they actually are, what their area of expertise is, and do they have the ability to stay within their swim lane of expertise, very timely with the Olympics on, that they're not going to stray into other areas, or they're not going to be persuaded or influenced to start straying outside of where their core expertise is. And effective and early communication can establish that by getting a gauge on how the expert expresses their thoughts, how resilient they are to say, yes, that's within my expertise, or more importantly, no, that's not within my expertise, I don't do that, or someone else is better placed to do that. To really set up the open and transparent communication that everyone knows what they're getting through the appointment process. Communication, though, at the early stages goes beyond their basic expertise, experience and discipline, right through to their communication style and the influence and communication methods that they have with their team, how they communicate with their team, how their team is going to communicate with you as instructing counsel, and really just working through their approach, their style, their manner, for ease of use of whether you can actually work with them, whether they can actually communicate in the early stages, and whether there's a natural fit that's actually there. The other key area of early and effective communication, I think, is finding someone who's actually collegiate, that actually you think you can work with. Litigation is a long journey, and the engagements that I take on, it goes both ways. I think about counsel I'm going to have to be working with, and their communication to me, to what I'm sensing, what I'm feeling. Are they listening to what I'm saying? Do I have the ability to raise issues or questions? Do I feel constrained in any way? Will I be able to have an open and frank conversation with them, with the paramount duty to the court on independence and objectivity? And is that natural fit actually there, that we can communicate and work together? And can my team work with the counsel team to maintain that? So early and effective communication is your first opportunity to select your expert to set the path going forward.
Campbell, if I briefly may jump in there. Very important and good point for this early communication. I was questioning myself just now, how do I actually find that out? A, as an expert, and B, I mean, that applies to both sides, B, as a counsel, whether the communication setting is the right one for me, and how do I find it out whether the expert is the right expert?
Absolutely, absolutely. And the early engagement, first impressions, actually do mean that you've got the right expert at the end of the day, because if that synergy is not there at the start, it certainly won't be there at the end. At a practical level, though, around the communication and what you should be probing, there's a couple of key themes that will be obvious, but I think they're worth exploring. The first is testing the expert. It's all very well having a CV that looks good, but get them to talk about their experience, get them to talk about recent matters, get them to name and expand on what the issues were in a case, who they worked with, what worked well, what challenges they faced, etc. Secondly, actually test the expert in communication, but will they tell you what you need to hear rather than what you actually want to hear? And in my experience or professional opinion, a good expert will always stick to the facts, but will tell you the answer, regardless of good, bad, or indifferent, with independence and objectivity in mind. But they'll have a point of view early, and they'll tell you where key risks might be, key challenges may come, and really giving you the good, the bad, and the ugly in that process. Thirdly, experience does matter. As I said, the more you probe, the richer the conversation, you'll really get to understand them and where they can assist your case, where their expertise resides, and what instructions they'll actually be able to handle. Testing the evidence, it's all very well to talk, but ask them, what methodology would you adopt? In your experience, how would you go about that? In your experience, what disclosure or discovery is going to be important to support your opinions? What challenges do you see? Is the timetable realistic? What haven't we spoken about that you thought we would have spoken about? Really get granular on what they think and how they go about things and the way that they can communicate that. Moving to the left, or my left, track record on the record. And as an expert, this is something that's fundamental to everything. It doesn't matter how good the expert thinks they are, the judgments are there, they're on the public record in the form of the databases and the court transcripts, but they're also there amongst your peers. Everyone talks as to who's good, who failed, who held up, who did well, etc. Probe on that and ask the question, have you had any adverse judgments? Have you had any challenging cases? Is there anything we should know about, etc.? And then lastly, communication really does come down to oral testimony. You know, how do they make the complex simple? How do they engage with counsel? How do they engage with the judge or tribunal members? How will they go in front of a jury if it's a criminal matter or a jury-attended matter? And really get a flavour for how they'll go under pressure, because under pressure you get to see the best and the very worst of people. You're better off seeing that early rather than later. If we just work through some key themes that hopefully this is something practical for the group to take away, you know, developing that further, communication is both written and oral. Let's not forget that. You've got to have a succinct report in accordance with court rules that's well structured, you know, straight to the point, clear, concise, etc. And then there's the oral communication. It's not just the evidence at the end of the day. It's their ability to be able to explain the concepts succinctly as matters progress, the ability to interact with the client at appropriate levels with clear separation and independence, and the ability to be able to communicate issues as it moves forward, both written and oral. The written piece too, though, is not just the report. It's an electronic age that every time I touch a keyboard, I have an expectation that that can be disclosed or discoverable. Through subpoenas in my part of the world where I've come from, or through an order of the court, that written communication becomes paramount because it is on the record for the record. Two is just around clarity on roles and expectations. really making sure they know what they're doing, what they're in for, and what they've been instructed for, and then how that will fit with the case. Thirdly is one for counsel on data accuracy. You've got to give experts the right data and communicate around that data and disclosure as to how they can apply it and how complete and accurate it actually is. It's important that if there are pitfalls with data or disclosure or challenges, communicate that, talk that through, be open about it, so you know the parameters on which the expert is working, that you're giving them the best you can with the available information to set them up for success, but being realistic on the challenges that data may actually hold. Fourthly, bias avoidance. This is one directly for counsel. Don't give the good news story to the expert, because a good expert will get underneath it and start unpacking it, and it will just cause problems, delays, and challenges where the issues are going to come up and surface whether you like it or not. Presenting information in a biased manner and communicating in a positive light, give it to the expert real, timely, and accurately so they can make their own assessment. 5 is feedback mechanism. Communication goes both ways. Finding the regular check-in points to be able to engage with the expert around where they're at, how they're going, problems they foresee, issues with timing, structural issues with data, the team, access, etc. Right through to the basics of communication of the timetable. When are you expected to meet with counsel? When are the barristers going to get involved? What will the preparation process be? How's the matter running in accordance with the timetable? When's their diary need to be blocked out for preparation, attendance, etc.? Just the hygiene on giving the expert the confidence that the full facts are being communicated and the timetable is clear, that they're part of that process and there is support that's there. 6 is around conflict resolution. And I've never done a job that hasn't had a problem, and problems happen all the time. As an expert, there's only one way to deal with problems, and that's to lean into them and discuss them with counsel. There are minutiae issues that cause conflict. It might be a tight timetable. It might be an ineffective communication that leaves the expert wondering, what have I been asked? Why am I being asked it? It might be unrealistic expectations. It might be gaps within the information. It might be frustration within the teams. Whatever it is, it doesn't matter. But a good counsel team will always support and engage with their expert and give them that platform to be able to express the issues, raise the issues, and resolve the issues before it becomes a bigger problem. 7 is communication around timeliness. Good experts are busy. Good experts have concurrent matters, and good experts have clashes in their actual ability to be able to focus on the issues and do the work. Upfront communication around timeliness, deadlines, draft submissions, etc. That is what good feels like, where it's very clear as to what the expectation is around timeline and having that communicated proactively and engagingly with the team. And then lastly, on communication, I've put in there resilience, and I underline resilience, that from me to you as a testifying expert, anyone who says they don't feel the pressure when they're going into the box and when they're in the box hasn't testified before. Every time I give evidence, I learn something, but it's a process, and you know you're part of that process. Communication that's respectful of, it's on tomorrow, you are well prepared, we're supportive, right through to the basics of, we expect it, you'll be there for 2 days, expect the unexpected, we're here for you, there will be a re-examination process. Whatever it might be, make sure that expert can express and communicate clearly that they're resilient enough to handle the pressure, but also make sure your communication recognises that resilience point by supporting them and encouraging them in the appropriate manner to make the process easier, smoother, and more engaging.
Campbell, if I may once again, I very much like the picture of the communication, really showing the interdependence of all these aspects. Probably on the point of conflict and resolution, I heard you saying earlier as well, for sure, communication goes both ways, but particularly that the expert needs, as I interpret it, is the feeling of having a room and with the opposite person, of actually being able to communicate and say, here is a conflict. How do you create that room as the opposing party, the counsel team? How do you, as an expert, actively see that such a room is created?
Yeah, it's a really good point. And I think it actually comes back to the first slide about early communication, to set the platform, the parameters of expectations. And to create that, there are obviously multiple law firms that I've worked with on multiple engagements on different countries. But the reason that I probably seek them out and the reason they seek me out is that synergy is there on trust. There's the obligation of the independence and objectivity, but then there's also the understanding that I won't die wondering. I will raise the issues, I'll ask for the support, I'll raise the challenges. And the only reason I do that is because they've built a relationship with me, they communicate effectively with me, and I know that it's the client that matters at the end of the day, recognising that things aren't perfect, but it's solution-driven. Of this is the problem, here are the solutions, this is what it could mean, have you thought about this, why don't you do this, or I can't do that, you probably need to think about this, is just that trust of working through the end game, knowing what's coming to deliver a solution that's actually going to work. The other point I would make there on the conflict resolution point, and refer back into the centre of the circle, is the stakeholder engagement. It's not just communication with counsel, but counsel have got a role to play with communication between experts. Unfortunately, there are times where it's common in a number of jurisdictions to do concurrent evidence or joint witness statements and reports. That process is either highly effective, in my experience, with sensible experts narrowing the issues, working through the differences, difference of instructions, areas of agreement, areas of disagreement, or the process is ineffective where there's conflict or grandstanding or combative communication and negotiation of the experts that actually doesn't serve purpose. Counsel have a role there to communicate effectively there on the warning signs, to manage a process that is fair, transparent, etc., with the end in mind to make sure there's value in that process. The final point on that, which I will add, is also communication or stakeholder engagement with the judge or the tribunal members. Arbitration work, I think, holds true of more engagement from a panel that are asking an expert questions, are really seeking to understand differences, are really looking for assistance in narrowing issues, explaining issues, etc. Don't underestimate the influence the counsel can play on that process by positioning it in a manner that's streamlined, effective and efficient to provide that opportunity and platform for engagement and communication. If I then come back to the theme that I've mentioned many times, independence and objectivity, okay, independence simply for the expert is, are they truly independent in terms of unbiased opinions without fear or favour for the answer in accordance with the court rules to provide an honest opinion. If I tie the independence point to communication, I often say it's not a question of being right or wrong. It's a question of explaining my opinion and why I hold that opinion and what supports that opinion. If that opinion is different to another expert, so be it. But communicating that in a way that is transparent, independent, and serves the objectivity obviously assists the process. And to make that practical for the group without going into accounting world and accounting speak, I'm often asked, why can you have two senior partners from two different accounting firms give two different opinions? And the answer is sitting with the uncomfortable is okay, because often accounting standards, valuation techniques, etc., require judgment where there is no precise answer, or there are multiple inputs that drive the answer to what the opinion might actually be. And if you think of that in communication, it's covering all bases as to why there might be one perspective to another perspective, etc. Secondly, I practically remind myself in the work that I do, often you have to get the wrong answer to get the right answer. If you get both, you know everything's covered and it's a well thought out opinion that can be substantiated at the end of the day. That actually comes down to communication by asking the right questions, probing in the wrong areas, the ability to engage independently and work through those issues. The objectivity point is a simple one. It's mindset and it's discipline in practice. You are not there to win. You're not there to lose. You're there to assist the tribunal and the court. So bring an objective mindset to all communications, written and verbal, within the context of the litigation arena. A couple of call-outs on that. Ensuring that reports are not aggressive, that they don't have emotion, they're standalone and factual. You're not there to win the case. Transparent and fluid communication will always prevail, bearing in mind there might be a wrong or a right answer, but it's articulated in a professional, non-confrontational or adversarial capacity that will always drive a better outcome for the expert at the end of the day. I've added a quick slide as a takeaway. So you might be saying that's all very well, Campbell. What does that actually mean in practice? But there's two things I'd encourage you to think about in your communication and this handling of bad news or interacting with the expert. First, I would be encouraged a thorough and thoughtful expert response. Give them the opportunity to put it out there, explain the complex and work through. But give them the opportunity through your communication and the probing questions of inviting that communication to explain issues of sensitivities, how sensitive is the issue, what could the alternatives be, etc. To work through any material risks or changes if they were to crystallise, what impact would that have on the report, the quantification, etc. And the counsel teams would be well aware. A lot of the inputs are based on instruction, on the lay evidence that is there, other expert evidence, etc. Really testing if that was to change, what impact would it have, and getting the expert to explain that. And then lastly, it's deliberately pointed and phrased the way it is. Are there points in the report that concerns the expert? I'm certainly not advocating that a good expert would have points of concern in a report because it means their report is wrong and it's not independent. But really testing around, if you were on the other side or the other expert, what are the challenges that they would have with us, taking us through the sensitivity there, the rebuttal points, the areas for cross-examination, and frankly, the areas for challenge. Where do you think the challenge will come? What's the answer? What's the response to why can't we close the gap? If I pivot there to the supporting environment to engage with your expert, a couple of key call-outs here. Discussing issues openly and transparency while respecting independence and objectivity are key, but providing that platform for honest conversation. Secondly, giving them the environment to be able to communicate their views. Don't jump to conclusions and don't leave the expert hanging when they're trying to explain something or probe something or communicate something. Ask those probing questions. Is there anything else? Can I just replay that to you? Is this what you're thinking? Is this where it impacts? Is there anything else that you'd like to add that you think is important to us? That goes a long way to getting it all out onto the table to avoid any surprises. The other question or comment that I would make on this at a practical level is, as an expert, when you've been engaged with a counsel team for many years, working on very complex issues, it's really disappointing when counsel, when the pressure builds, don't want to listen to what you're communicating. Give the expert time, oxygen, and chance to be able to explain their thinking, their methodology, etc., and listen to what your expert is saying. because you're better off knowing the ins and outs of what they are going to say early in preparation rather than when they're sworn in and it's too late. Cutting experts off, assuming you know, really probing and giving them that platform will obviously go a long way to giving great success. And then finally, hopefully some takeaways for you to reflect on today's session. I've put the do's and the don'ts around communication just to try and summarise some of the themes that we have coming through there. I'm not going to call out anything specifically here other than address the common issue of around influence, drafting, markups. Why don't you say this? Can I suggest this? Just don't do it because it will come out at the end of the day. Two, a good expert will control that process. And I often say, thank you very much for your markups, but here's the report. There are no markups because that's my opinion and that's the report. And thirdly, on the good, work through all of those and have the mindset right pre-conference to say, am I addressing those issues and am I providing the right environment for my expert to be successful? On the other side of the don'ts, again, self-explanatory, but really focus on, am I straying into an area of influence? Am I communicating in an unbiased manner? Am I giving the full facts? Am I really going along for the ride and just assuming I know what's happened when I don't and not putting the brakes on? And am I respecting the professional boundaries and recognising the importance, the impact that an expert can actually have to fulfil their full potential with independence and objectivity in mind? So I'm going to pause there. That's a lot to cover in the time, and I've probably gone over by a few minutes, so I do apologise for that. But I'd really welcome a chance to open up the conversation. And if there's any questions from the participants, I'd be more than happy to answer them on today's session.
Well, first of all, thank you very much, Campbell, and no need to excuse because I did ask a couple of questions in between, so your timing needed to take that into consideration. For sure, the floor for questions in our Q&A is open, so whoever would like to turn on the mic, please feel free to do so, or raise questions in the chat if you have any and want to take the chance to address those questions directly to Campbell. In the meantime, I actually do have a question, quite concrete probably. You addressed the aspects within your wheel and now in particular also with the don'ts of bias and avoiding conflict situations. Have you ever encountered a situation where an expert was actually challenged, and could you elaborate a bit on the background?
Yes, yeah, I can expand on that personally, and again, it's on the public record. But cross-examination is intense, and cross-examination comes very thick and fast when you're first in the box and they're working through independence and objectivity. A common area of challenge there is around audit relationships and the work that a particular firm might do for a corporate and the guardrails and parameters to ensure that independence, perceived or otherwise, is always maintained. So being questioned around how you've maintained your independence and protected yourself and satisfied yourself of those independence considerations is often an area of challenge and quite some force that's there. It might be a client of the firm that you've had a previous relationship with, where you've never spoken with the client, interacted with the client, etc. But the bigger firms have relationships across a global footprint. It's the consideration and questions around previous work that you have done. On the one hand, a good expert will be very transparent and upfront around the work, interactions, etc., under the court and arbitration rules of where those relationships are. On the bad or the don't list is where those relationships only come out through cross-examination and only come out around points of where certain work may have been done that is in direct conflict with the issue, where other parts of the firm have been working on particular issues that intertwine with the matter being litigated, and not having that objectivity and perceived or otherwise independence of that work. So it will come out and it will be tested, and bringing that back to the communication point, that mindset to put down exactly what you have done, to where you are and how you meet that criteria is a key component of it. The other area where that comes into play is the CV itself for the expert. It's all there publicly, what work you have done in the past, why you're independent, how you're free to take on this engagement, etc. It's always an issue, but transparency is the key. It is what it is. You've done what you've done, and you make your decisions there in a transparent manner for all to see.
I see. Thank you very much. We do have one question from the audience. Svetlana posted something in the chat. Svetlana, do you want to turn on your mic and ask your question directly? She does not want to turn on the mic. It's the question is not as precise. It's a general question or comment. Probably it's on the 2024 new trends on legalese communication, stating the conflicts probably with clients versus with colleagues versus with the court. If Campbell, you have directly a comment on that. Otherwise, Svetlana, you could probably phrase a more concrete question. But Campbell, you nodded already. Probably you have something to say.
No, other than the facts are the facts are the facts, and everything comes out at the end of the day. It's complex, the world we live in, with commercial relationships, audit relationships, previous work, etc. And I come back to what I've repeated over and over again: independence and objectivity. It's really simple. If you step back from it, does it meet the criteria or doesn't it meet the criteria?
Good. We have another question. Probably it's Meredith, I guess. If you do want to turn on your mic, Meredith.
Sorry, it's a bit early here and I have a little one, but
all good.
The dues, I think very much lead one to a thorough, productive engagement. And I think it raises an interesting question, because often increased activity results in increased spending. So I would be curious if there are any thoughts on how to navigate those recommendations for situations where the client may be more cost sensitive and one is trying to balance, review of all the data and reporting on a regular basis with concerns about spend.
Yeah, that's a really good question and a really good challenge. And I think to answer that, I'll make an additional comment that the do's and the don'ts aren't necessarily prescriptive, implement them and do them. I think they're more thematics of thinking through the issues with the matter that's in front of you, given the constraints, timing, fee pressure, etc. But if the thematics are in the back of the mind with the right intentions, I think they will surface regardless of the effort that is required to deliver the same outcome. So it's mindset rather than procedure that I think that can regularly be or can actually be applied. It might just be at a different scale of one end of a matter to another matter. So it's mindset rather than practice.
Thank you, Campbell. Are there any more questions? I see Mihaela is turning on her camera.
Slowly appearing on the screen. I have a question about the relationship with the clients. Did you have in your past to drop off a client relationship because of issues that appeared along the way? And if so, do you think there were some communication issues, or do you think something could have done from a communication point of view to overcome that?
Sorry, just expand on that a little bit for me. This is conflict or issue?
Sorry. If it happened in your career to start working with a law firm or a lawyer, and along the way, you just realized this is not working out for you, and you had to completely disregard the relationship, do you think you could have done something from a communication point of view to avoid arriving to that point?
Yeah, that's again, that's a really good question, and I'll answer that honestly. That yeah, absolutely. I've had different engagements where I've actually resigned as an expert for a variety of reasons, whether it be the quality of the instructions, the quality of counsel offering support, the ability to influence, where I've actually walked away and said I'm not in this any longer because it's not been done under the right process. Secondly, I frankly and simply, I've walked away on fee-related issues where I haven't been paid for the detailed work that I've done, and that can be a sequencing issue sometimes of they see the report, they see the opinion, and frankly, it mightn't suit their case, and then it becomes a fee issue that's there. I always say to my team, I value my time and I respect my time, and a fair fee for a fair job. If the work has been done without fear or favour of the opinion, why shouldn't it be paid? And I've actually walked away from engagements. That's actually gone one step further and been quite awkward, where I've actually been subpoenaed to give evidence to be effectively a hostile witness, where I haven't been paid, and that's a whole different story that can get quite messy. The other area where I've walked away is where there's no visibility of counsel, that you're interacting with the client and the client's telling you what they've done and the model that they've got and why it's right, and the process falls apart because there's no instructions, there's no independence. The process is just too close for the client giving you something rather than having counsel driving the process and putting the guardrails up that are there. And then finally, a phrase that was used many years ago, and I won't say who or where, but I did have a senior barrister once say to me, Campbell, that's a very good report, it's very concise, a very good piece of work, but could you make it a little less clearer? And they were basically saying, we haven't got the answer we want and we're in trouble. And obviously, if you've listened to everything that I've said today, the answer is no. The report's signed and that's it. It is what it is. And that's not disrespectful to senior counsel, but that's where it gets to the pointy end sometimes, that they're stuck with something in the process, and that's it. It's not going to change, or it's not going to be influenced, certainly if I'm involved.
And do you think you could have done something different from a communication point of view to avoid arriving to that point?
Yeah.
You or maybe the other side?
Yeah. Early intervention will always drive a better outcome. I could have been more proactive in certain circumstances. I think often you're so focused on getting the job done when it comes to fees and work and managing budget, expectation, etc. And I haven't done a job where I haven't learned something, so you always get better on that. But yeah, reflecting on some of those early experiences, yeah, I could have managed it earlier, or I could have at least put the flag up and said, we've got a problem here, go back to the wheel. We need to work through what's happening here.
Thank you very much.
I think we do have time for one final question. Sveta, you raised it in the chat.
Hi. So my question is whether you've seen any sort of characteristics or qualities in lawyers, and maybe particularly associates rather than partners, that made it particularly effective and pleasant to work with. So I guess from a communication perspective, and probably any sort of complementing characteristics.
Yeah, again, really good question. Maybe I'll answer that with a comment up front before addressing the question. But the more experienced an expert becomes, I think the more they have their qualities that they're looking for in a counsel team. And that's, no one's going to die. We've got a job to do. So we might as well have transparent communication, bit of fun along the way, get to know them personally. Good junior counsel engaging in that process. And I like it when they engage with me, that there's, a bit of chit chat about your family, or what are you up to? How's other work going? Really understanding the dynamics of where the expert is or what's going on in their life. Two, where the junior team actually interact with my team. And I find that's where the magic happens, because if they can cut through the detail, work together, build the platform, it rises up and it makes it more efficient and effective, that they're very good at communicating. And then finally, junior counsel that have an opinion or ask a question. I've never had a situation where I've received a dumb question, and everyone's probably thinking the same when it comes to accounting and finance issues, right? Lawyers have engaged an expert to assist in that area of capability and technicality. If you're thinking of the issue or the question, ask it, because everyone else is thinking exactly the same thing. And good junior counsel will have a voice in the appropriate manner, but saying, can you explain that? Can I replay that? Would this be right in my understanding, et cetera, et cetera.
Thank you.
Thank you, Campbell, for this answer, and in particular for the whole episode. It was very insightful. And I think you gave the audience quite a number of practical advices and critical points to reflect their communication skills and in the end to enhance them. So that was very nice. Thank you very much. To the audience now again, we will publish the recording on our YouTube channel, where you find all the recordings of our episodes, and we will also for sure publish it on LinkedIn. We will also have a short summary of this session that will be published with Use Connect. And finally, the last word is some marketing for the next episode. It will also focus on communication skills, as it is for the whole season 1, but we are going into written communication and focus on drafting and written advocacy. Very much looking forward to that one. And with that being said, we are closing today's event. Thank you very much.